Welcome to the Personal Injury Law Show. My name is Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got Nunzio Tartaglia, personal injury lawyer in insurance law in a law firm. Good evening, Nunz.
Evening, Tony. Viewers, welcome.
And Alice Robinson, an associate in a law firm in insurance law. Good evening, Alice.
Good evening, Tony. Viewers.
Viewers, tonight we're going to be taking up the debate about innovation as opposed to med-neg, and it's going to be very intriguing.
Before we kick off though, Tony, what's been in the news?
Well, fellas, there's been a lot of stories in the news. This week we're talking about the Ambos Nunz. Tell us a bit about this story where there's a lot of concern that there's about 300 attacks a year, and what do you do to protect the ambulance people?
Yeah, Tony, look, there's been a rise in attacks on ambulance officers, and it seems like it's getting progressively worse, unfortunately. And now the debate's centering on what can be done as opposed to, you know, being first to the scene and being quick on the scene. So it's a bit of a double-edged sword the way I look at it, because you want to get to a scene first and, you know, make sure people are safe, but then you're bringing ambulance officers into a situation where they're not sure exactly what's going on. So training is a big issue.
Alice, what concerns me is that if you've got a real emergency and say someone's OD'd on drugs, they're going to be waiting for police to attend before they actually start doing what they're doing. That's got to be a concern, surely.
I think that's right, Tony. And one of the things that the news article talks about is the fact that some patients, even though they're in distress and they need help, have been a bit violent or a bit dangerous towards ambulance officers. And that's, I think, what Nunzio means when he speaks about double-edged sword. It can be a bit dangerous, I think, and they will be waiting for police, so the ambulance officers have that extra layer of protection as well as the injured patient. So it is a bit of a concerning situation.
They've started a violent working group, so they're working through the issues. But I think, you know, if you combine training and you know, some better techniques, it's one of those. I don't think it's one of those situations that can be permanently fixed.
I think that's right.
It just needs to, you know, progressively get better in terms of stats.
What about one particular instance? Someone was chased with a pair of trauma scissors. I'll tell you what, that's pretty scary stuff, isn't it?
Yeah, I think so. And presumably those scissors came from the poor paramedics themselves rather than from the patient. But it's always a volatile situation when you've had accident or trauma, and I think that's something that can't be controlled by the paramedics. It's almost you get what you're given when you arrive.
I think we should get someone from the ambulance service in to discuss this issue.
No, definitely.
All right, let's keep moving. Interestingly, Alice, they're going to drop the limitations on child abuse claims. In other words, instead of having the mandatory 3 years to sue, then you've got the long stop, which means 12 years. With any case involving child abuse of young people, there's no time limitation.
That's right, Tony. This is a major development in civil litigation for victims of sexual abuse or child abuse. Traditionally, you have 12 years to bring a claim when you've been injured by somebody else. That is a civil claim for compensation. And the state government has decided to amend the legislation so that people who've been abused decades ago could now bring claims where before they would have been locked out of that particular entitlement. So it is really good news for people who don't often speak up because there's a lot of shame and a lot of sort of embarrassment around these kind of claims. So it is really great to see that they have that opportunity.
Nunz, it's amazing how in the last couple of years there's been all these stories coming out of England with those radio presenters and Gary Glitter
and also the church
Rolf
as well.
Harris.
Yeah.
It's just extraordinary, isn't it?
Yeah, look, and that's why I think it's motivated these changes, and the most important part about it, they're going to apply retrospectively, so which they need to, obviously. And so, look, I think it's a smart move and it's wise. And as Alice said, these types of cases, your symptoms don't sometimes come about till later. Yeah. And so if you've been abused as a child, you can hide that up for years to come. And when you're comfortable enough to come out and actually confront it, that's when you should get a right to sue. And I think it's a great, great introduction to law. So.
Well, I acted for one that was 50 years old a couple of years ago, and he had massive anger issues, and he was abused when he was only 5.
Yeah.
So it's amazing what it does to their lives. It actually destroys their lives.
Oh, it can, and they deserve compensation if that's the case.
Of course. But the beauty of this is that they can get compensation and sort of help themselves at any point in time when you're ready to go.
And look, I think it's always been that fine line. I find it very uncomfortable when someone has been accused of child abuse, but then they can use the law to get out of the situation.
That's right.
By saying you're out of time. I just think that was so wrong, and this is a great initiative.
How outrageous is this issue of Fistville, Alice, where Paul Ted Potter dies of about 12, 13 cancers, and they kept an eye on that it came out of where he was working, and all of a sudden, after they've assured everyone that it was a safe place to work, they've found toxic water in the drinking tanks. It's outrageous, isn't it?
Tony, this has been a long ongoing issue. Fistville in particular, I think, is something we've discussed in the past, and there are a lot of people who've been really badly affected by this contaminated water, and to see that it's being shut down, to me, is probably a good thing, to be honest, because at least they're cutting it off at the source, so to speak. But also, I think that it's not just going to go away because you shut the factory down. I think that there are still many issues that are going to arise out of people who might not know they're sick yet.
And it's cost the top 2 people their jobs, Nunz?
Yeah, the 2 chief WorkSafe
the chairman of the board?
have basically stepped down.
CEO.
Premier Andrews basically said he lost confidence in them. And look, Fistville's been an absolute disaster. Let's just be honest. And I think it's going to be in the news for years to come, because now with that report that came out about what actually happened there's going to be some litigation going for years on that. So.
Well, the beauty of it is that I think there will come a time where the firefighters can get proper compensation.
It needs to be a package of some sort, doesn't it?
And I think it's going to get to the point where we won't have to worry about having to prove it. I mean, it sort of speaks for itself, doesn't it?
You'd like to think so, but it's not working out like that at the moment.
Nonce, in the United States, 2 teenagers went up parasailing, and in strong winds, they lost control.
Yeah, the parasail snapped free, and look, unfortunately, I think they landed on a 13th level in an apartment building, and then fell to the ground. And they got lifelong injuries, and doesn't talk about or speak of the amount of compensation, but it's in the millions from what I understand.
Presumably it'd be large. And these are 2 very young girls, only 16 and 17 years old, and they did have some really nasty injuries as a result of that fall. And the fact that that harness is snapped, I think, talks a lot about, the dangers involved in these types of sports.
How slack is that, really, when you think about it? How can a harness break?
Well, look, Tony, I know I've seen at the firm recently, I've had so many incidents of skydiving issues, and these type of activities can be dangerous, and it's contingent on weather, safety practices and the like, and if you're not stringent about it, it can cause basically lifelong injuries like that, so got to be careful.
Nunz, are you surprised to know that your Red Bull that you generally love to drink when you're tired
gets me through the afternoon,
got some real issues in terms of health?
I hear it could, Tony. It's an allegation at this stage.
Alex, what do you say about it? I mean, there should be tighter controls on these energy drinks. That's what the Associate Professor Miller's saying.
That's right, Tony. There's a suggestion that the energy drinks have content which is harmful to people who use them over a long period of time. So we'll have to watch that space, I think.
Viewers, we've got to go to a sponsors break. Stay tuned. After a break, we're going to take up the debate about innovation versus medical negligence. Viewers, welcome back to the show. Before the break, we spoke about innovation as opposed to med-neg, and it's a very intriguing topic because what we're going to talk about is there's conservative and traditional means of treating people, and there's a Lord Saatchi in England who's advocating innovation, which means that patients will be getting treatments that aren't part of a norm and they're not conservative, and then the debate's going to be, if you take that line of attack in terms of treating someone, will you get sued? And does it stifle new treatments by placing doctors in this situation? Before that, I just want to quickly deal with this issue of the hip replacements, Nunz. There's a massive class action against Dupuy and Johnson & Johnson. I think there's about 5,000 people in this class. Tell us a bit about the facts.
Yeah, so it's a class action. I think it was commenced in about 2009, Tony, where there's issues regarding a hip replacement that's obviously made by these two companies, and basically they're saying that the hip replacements are meant to assist, but in these regards it hasn't. It's been more wear and tear on the body, and they've had to have revision surgeries, and that's the basis of the class action. And look, it's not the first against these particular companies, and they're defending at the moment, but where that leads, we're not sure at this stage, Alice. What do you think?
That's right. Look, that's right, Nunz. The Dupuy action has been ongoing for a little while now, and it essentially involves hip replacement or prostheses that have been deteriorating once they've been put inside somebody's hip. And there's talk of things like cobalt poisoning in people's blood, and obviously rather than helping a patient recover, that makes the whole situation worse. So it is a pretty significant class action in that regard. And as you say, I think it'll be interesting to see where it leads, because the companies are vigorously defending it, but there's good evidence out there, as I understand it, that these hip replacement prostheses are a bit of a problem.
Alice, in mid-2005, there's an allegation that Dupuy were aware of problems, especially of metal breaking off the ball and releasing into the bloodstream. So they're pretty significant allegations, don't you think, Nunz?
Look, if they're proven, Tony, I don't think their defence is as strong as they allege at the moment, because they're just saying that they did everything properly by the book, and that there's no foreseeable risk of any injury to these patients. But if they're aware of this, I think that changes the landscape.
Changes the case significantly, I think, especially where you can show knowledge.
We'll come back to this, viewers. Now let's get on to this business about innovation. Alice, Lord Maurice Saatchi lost his wife to ovarian cancer.
That's right.
Back in 2011. He's proposed a medical innovation bill. What are we talking about here?
Look, Tony, this is a really cutting-edge piece of legislation. Lord Maurice Saatchi did lose his wife in 2007 to ovarian cancer. And one of the things he said to the Parliament when he introduced this bill in England was that whilst he had no quarrel with the doctors who treated his wife and the services that were provided, he felt that they were restrained because they couldn't use innovative treatments on her. And obviously, he feels there's a bit of a lost opportunity in relation to her treatment. And this bill essentially talks about freeing the doctors up, if you like, to try treatments which perhaps haven't made it to clinical trial stages yet, or perhaps medications which are brand new and haven't quite been given approval, in the hopes that it'll do something for the patient where previously you stick with what you already know, but it doesn't really do anything in the circumstances. But it is a controversial bill. There's a lot of chit-chat out there about it, and it will be interesting to see, A, if it passes, and B, if it affects us ultimately.
Nunz, Lord Saatchi in particular argues that the law impedes medical progress because doctors will not depart from a standard procedure for fear of litigation. On the back of that, let's go to the Boland principle in England. There's a case of Boland and Freehan Hospital Management Committee, 1957. Tell us a bit about the facts of this case. That way we can understand where Lord Saatchi's coming from.
Yeah, look, Tony, this was a case, I said, back in 1957, so it was a while ago when the plaintiff in this particular case was undergoing convulsive therapy, electroconvulsive therapy for a mental illness. And this particular doctor didn't prescribe, I think it was relaxant drugs. Relaxant drugs, not sure their name, but didn't prescribe in this case. And there's evidence in the case about, I suppose, the do's and don'ts, or the pros and cons of not prescribing that drug. And that's basically really the tenor of this case, whether he should have, and was it a breach of duty, Tony?
Now, because he didn't prescribe this relaxant drug, what happened to this particular plaintiff?
That's right. So, Tony, when you have electroconvulsive therapy, or at least when it was being administered back in the 50s, one of the concerns for patients was that their bodies become very rigid during the therapy. And the relaxant drugs were usually prescribed to avoid the risk of a fracture or some kind of damage to the bone structure whilst the treatment was ongoing. And in this case, the patient did suffer a fracture and wanted to sue for that loss, even though there was evidence to suggest that if you prescribe the relaxant relaxant drugs, there was a tiny risk that the patient could die, whereas if you didn't prescribe the drug, there was a small risk the patient could have a fracture from the electroconvulsive treatment. And so the plaintiff brought that case on the premise that he should have been given access to that relaxant drug, and then he would have avoided the fracture.
Well, the matter went all the way to the House of Lords,
Right.
and they said that a medical professional is not guilty of negligence if he's acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art, medical men and or women.
And that's why they refer to it as the Boland test now, and
Yes.
basically bringing in a team of doctors to say, well, was that done correctly, or should that been administered? And in this case, they said no. So
In Australia, viewers, we don't really have the Boland test. We've got something similar to it, but our law's been settled in a case of Rogers and Whittaker. Very interesting decision in the High Court.
Yeah.
What are the facts of this one, Nunz?
this is regarding an eye injury, and again, this was back in I think 1992. So considerable time after the Boland case. Effectively, it's more of a case regarding failure to warn. This was an eye case in which the patient wasn't advised of the risk of surgery, and that's where this case. Look, I know we don't follow the Boland test, but when I was reviewing these articles and the case, it's very similar, isn't it?
It is similar. I think in
Legislation is similar.
Boland, there was no warnings given. That's part of the problem in that case.
In this particular case, she was awarded over $800,000, and the doctor appealed to the High Court and failed.
And he lost ultimately. That's right. And one of the things to come out of the Rogers and Whittaker case was that this particular patient had a real problem with the eye operation. She had one good eye and one bad eye, and the surgery she was having on the good eye was cosmetic only, and she was really concerned about losing the sight. And what the court found ultimately was that she'd made those concerns known to the doctor, and it became more about what a reasonable patient would say yes or no to when warned of the risks, which opens up a whole different debate that we might not go into today. But ultimately what it established was that Boland really didn't apply, in the sense the doctor couldn't bring in a team of mates to say, well, we agree with what he did, so it's fine. It was more about what the patient wanted, and that changed the game significantly for us.
Well, the patient said that if she had been warned about the risk of losing her sight, she would not have had the operation. That's the key to it.
That's the key to that case.
So Alice, you're saying basically in Boland they're saying, well, let's bring a team of doctors, they make the call whether it was reasonable or not, whereas in Rogers Whittaker they're saying, bring in the normal person, these are the facts.
Patient.
What would you do?
That's right.
Viewers, we've got to go to a sponsors break. Stay tuned. We'll take up this debate after the break. Viewers, welcome back to the show. We're talking about innovation and the old rules as we know it. Our common law has been modified under Section 59 of the Wrongs Act 1958. It basically takes up the Boland principle and Rogers and Whittaker. It's like a mishmash of the two cases.
Bit of a mix.
Yeah. But we adopt both, where if a body of professionals say that what you've done is widely accepted, then you can't be held negligent.
That's right.
Unless you're so grossly negligent in the way you conduct the procedure.
Yep.
But Lord Saatchi's advocating a bit more than that. Nunz, what the supporters of the bill that he's put forward say about it?
Look, the main, I suppose, premise of the bill, and it's funny, it's such a small bill for, I think, such a big issue.
Yes.
It was only 3 or 4 pages, which is remarkable for a bill of parliament. But yeah, basically, the big premise for it is that it encourages innovation, and it allows doctors to, I suppose, be adventurous, but at the same time safe within the realms of the law to make sure that no one's taking advantage of in that regard. But it doesn't stifle innovation, promotes it, and in the medical field we know that there's technology just improving day and day, and I think it assists in that regard. But that's the main premise of it.
But Alice, This bill that he's advocating still requires a body of doctors to accept the innovation, doesn't it?
It does to an extent, Tony. It requires that the doctor looking to innovate, so say if you're looking to use a new medication or a new procedure, to consult at least one other doctor and have a written record of your discussions in relation to whatever you want to do that's perhaps unusual or innovative in this case. Although I noticed in the bill that the bill doesn't talk about the doctor who is being consulted, so that is the person you go to ask about your new idea. It doesn't talk about whether they should have spoken to your patient or know your patient's history, and it also doesn't talk about their minimum qualifications. So I think there is some scope there for risk in that regard.
And you've still got to get the consent of the patient.
Look, I think that's without doubt.
You know what I mean?
Yeah,
You've still got to get the patient to consent.
That part that Alice is referring to, I think the flaw of the bill, to be frank with you, because you've got there's going to be an independent doctor, or could be, but they're not speaking to the patient, not looking at their medical records, they're not really across the details which I think are required to make that call, and they can tick it off and say, okay, you're not going to be sued if something happens.
Arguably,
I just think that doesn't work.
That's right. Arguably, you could have this conversation about innovation in a coffee shop 10 miles from the hospital, for example. You don't need to be anywhere near the patient because the bill doesn't set that out. As a matter of logic, presumably the doctors talk about the patient's history and so on. But I think it's got potential for pitfalls because of that sort of a hole, if you like, in the bill.
Isn't it a case that in Australia in particular, we're a very conservative society?
We are,
and if you have a look at the medical treatments, and I'm not having a crack at our doctors because I think they do a fantastic job. If you have a look at our history, traditionally, very conservative. Yep. A lot of the things that are discovered are outside this country in terms of cancer treatments. Although we've had the bionic ear, which is fantastic. They're starting to talk about a bionic eye. Yeah. They're talking about a bionic heart, or a heart that runs on some sort of mechanical device. But do you agree that we're a bit conservative in that regard? I
think there's two reasons for that. I do think we are conservative to a point, and we put our trust in doctors when we go for treatment of any kind. But equally, if you take back what we were talking about, Section 59 of the Wrongs Act, which is a little bit of a mishmash in relation to what the court looks at when the doctor ultimately gets in trouble over alleged negligence. The court looks at not only what the peer professional opinion or what other doctors think. The court also looks at what the patient would have done, what's been said to the patient, what the patient's choices are. And I think that you get a result of what they call defensive medicine, because the doctors are not only treating the patient at the time they're giving the treatment, they're also thinking about what might happen if it doesn't go right.
And that's what Lord Saatchi, that's his motivation with the bill. He wants them to be free of that and say, well, I can really, explore all avenues and say, let's see if we can get you better.
That's right.
And that's the motivation behind it. But whether it's a fine line, though.
Well, if you have a look at some of the things that in recent times, especially they've discovered this new treatment that deals with hepatitis C, and that could save quite a few people in the future. Apparently Ron Walker recently was saved by this new treatment in relation to melanomas.
That's right.
I mean, none of these are on the PBS yet. So these two treatments in particular, at some point in time, someone must have been given these drugs to test or trial to see that they actually work.
That's right, and that's something that usually happens in a clinical trial, which are often funded by drug companies, and there's politics behind that because the drug companies generally tend to fund clinical trials where they know they're going to make a profit at the end of the day. And that's where people miss out on those more kind of unusual treatments or those more unusual or lesser known diseases.
You've touched on something very, very touchy, topical.
It's true.
That's part of it. That's one of the things that they say, that a lot of the reason why there's not much in the way of experimenting, for want of a better word, is because the drug companies don't want to put money into things that aren't going to make them money.
No, ultimately they're there to make money, and if they don't make money, then they go bust. So it's dollars and cents in the end, unfortunately.
What do you think, if we had someone in this room that had a cancer and was terminal, they would probably be amenable to taking anything, don't you think?
Look, it's probably right, and I think there's a degree of vulnerability there as well, because the patient who is, for want of a better word, desperate for that magic treatment that might give them the second chance, I think if you say to them, well, there's this untested drug that might help you, on the balance probabilities, they're likely to say, yes, I'm happy to try it, I'm on the way out anyway, not to make light of the situation. But I think the idea is there with this bill. I really do. Yes. I think the idea is there. I just think perhaps if you look at the context and look at what happened to Lord Saatchi, perhaps we're looking at something that doesn't quite cover all the bases.
I agree with Alice. I think the concepts there, the mechanics aren't there just yet, and I don't think it's foolproof enough. And I feel like then it might actually promote mavericks and just to say let's try anything.
The sad thing is that when someone's so desperate, that's when all the rogues come out of a woodwork too, to some extent.
Yes, you get the
Because it's a good
opportunists.
opportunity to make money out of people,
Yeah,
isn't
that's
it?
right.
Isn't it?
Yeah.
And it's sad because, I mean, you're taking advantage of people at their weakest.
At their most vulnerable.
Yeah.
And like you said, you know, they may only have 10 years to live. You say, well, let's give this a go anyway. But, you know, in Australia, you can be sued for that.
You can.
Even though if you shorten somebody's life, even though the end result was always going to be the same, you can be sued for that.
You
There's
can.
a recent case in which that happened.
That's right. And even when there's consent, you can still get in trouble. So I think that the mechanics need to be analysed. And you mentioned that the bill is tiny. It really is. There's about, you know, 8 sections or something like that. I just don't think it goes far enough to protect either doctors or patients ultimately. So
It's just interesting that recently I was talking to a doctor who does pancreatic surgery. He said they've tried anti-malaria drugs on mice and they seem to be working reasonably well.
yes, that's
So
right.
at some point in time, those drugs are going to have to be from the mice to humans.
Yeah, you need to move it to the next stage. And it's just costly.
And you almost need a bill like this to ensure that you don't get sued.
To promote
think,
that,
Nunz?
yeah, I agree.
Yeah.
I agree.
So I think, look, it's a pretty important debate. And I think it's something that we might have to get a doctor on the show
It's true.
to discuss it in greater detail.
Get the experts in.
Alice, thanks for coming on board. Nunz, thanks for coming on board. Viewers, thanks for watching. Go to the website, YouTube, Facebook and Twitter. Stay tuned for future episodes and always remember to stay safe.